Okay, Ross, we've been talking about crimes of passion, temporary insanity, murder versus manslaughter. Why don't you lead us like you always do and tell us the difference between the two, how it gets there, so on and so forth, etc., etc.
Well, I want to start with as far as murder is concerned, you got what we call malice. You got to knowingly do a certain thing or intend to bring about that result. And so here, I think a good starting point is when you talk about manslaughter and insanity, temporary insanity, things like that, is for any crime, there's usually got to be voluntary conduct and some kind of knowing conduct. Okay, it can be negligent or reckless, but the act that you do, right, has got to be voluntary. You got to know that you're doing what you're doing. Okay, it's just like for possession too. You gotta know. I think a good example is when we talk to jurors. Okay, on any kind of like drug case, a lot of times we'll put an object under somebody's seat or put it in a book and pass the book around. And when they have the book, when they sit down, we'll tell them to open it. When they open the book and that object is in there, right? Well, are you in possession of it? Well, no, because they didn't know that was there. All they thought it was a book, so they didn't know right the consequences of taking this book into their possession, so to speak. So legally, from a criminal aspect, from the criminal legal standpoint, it's not possession because it wasn't knowing and involuntary conduct.
That won't stop an officer if you see a little poppy seed.
Correct, and we're not talking about an arrest here. We're talking about can you beat the charge? Okay, and I mean sometimes this goes into whether somebody's going to indict, a prosecutor's going to indict or not, or whether a grand jury will indict is what is probably the proper terminology here. But it does make a difference whether you know what you're doing, whether what you're doing is voluntary, and so. That's essentially what these are sort of aimed at. When we talk about a manslaughter, we no longer have the involuntary manslaughter provisions. Those are in other parts of the code. There used to be a separate provision for that. Now we just have the voluntary manslaughter provision, which is the sudden heat of passion, so to speak. And that's when somebody has an adequate cause, a cause of death under immediate influence of sudden passion arising from an adequate cause.
Can we repeat this again? Because I was under the impression, I did not know that the terminology had changed. I bet you there's a lot of people out there too. Could you slow down? The involuntary is no longer, and now it's...
Well, there are still these things. They're just in separate parts and labeled in separate things. Okay, and so instead of having an involuntary manslaughter separate provision, right, we're attacking now just the voluntariness of something, or which is what I just explained, or whether you know what you're doing, okay, or whether there's going to be some kind of intoxicating effect that may affect on yourself, on the body, that may result in a different penalty, right, after the trial, okay, and that would be in the punishment phase. I'm going to talk about that. Okay, so just for voluntary manslaughter, though, we have this provision that talks about if there's an influence of sudden passion, an immediate influence of sudden passion arising from an adequate cause. Okay, and so we're looking at, and really the cases are all over the board. What's an adequate cause? I think most of us have heard about the scenario where we walk into the room and our spouse is cheating with somebody and we lose our temper, and the second half of that is, it's going to be an adequate cause is going to be one that would commonly produce a degree of anger, rage, resentment, or terror in a person of an ordinary temper sufficient to render the mind incapable of cool reflection. And so that was a lot, but it's really common sense kind of thing in the normal aspect of, I walk in, I see my spouse cheating. Obviously, that's going to cause a sudden influence of passion, rage, right, or anger that's going to make me think. But make me act without thinking.
Ross,
okay?
In this day and age, let's move sideways in what you just said there. In this day and age, people get so upset if a mother or a father spank a child in public. Could that effect be the same thing where somebody goes, I cannot believe you just struck your child, and they go to protect the child? Could you apply that to the snowflake age that we live in?
So, obviously, this is open for any adequate cause. Now, I will say this, that if what they're doing is a legal act, Okay, if what they did was a legal act, then a lot of times that's not going to be seen as an adequate cause because it's not legally adequate. It's insufficient to give somebody a right to act on it. You got to remember in that scenario too, you're going to have the right to protect third parties. Okay, and so you've got a right to step in and protect the third party if you think that they're being abused. And in fact, a lot of times, a lot of people are going to have an absolute legal duty to step in and do something, at least report it, right, if they see a child being abused. And so if that comes about, I would think that, I mean, we could sit here and hypothesize for days.
I just use that because that's been a common one that people get upset with nowadays, is that you strike your child for discipline purpose, not for physical harm, but for discipline.
So could it possibly be an adequate cause? Yeah, I suppose that it could if there's enough there, but again, there's no way for me. This is a fact-intensive kind of thing. It's a fact-by-fact, decision. It's a case-by-case basis, right? And so, I mean, yeah, I that may be possible. If that was there, though, if the adequate cause was there, I would think that the person, there's no reason why they wouldn't want to use the defense of the protection of third parties. And one reason is because this is not going to be an affirmative defense. Your sudden heat of passion type of manslaughter charge is not going to come in the factual part of the trial, whether or not you're guilty or guilty or not guilty of murder. What it's going to come in is the mitigation phase in punishment. So you have two phases of trial. You're going to have your guilt innocence phase, and the jury's going to decide did you or did you not commit homicide, right? And then after that part of trial is over, right? Then you can go to a judge or a jury. Again, you can ask the jury to decide for punishment, right? Whether that should be mitigated to a manslaughter.
Okay, so just to recap, what you're saying is you're either guilty or not guilty of what you actually did. Yeah, you did that, but now because of certain circumstances, we can, depending on what it was, determine if it was the manslaughter or first-degree murder in that respect.
And so then you've got the recklessness aspect to the manslaughter charge, not just the sudden heat of passion. So the sudden heat of passion is going to be a mitigation of the murder charge, right? The manslaughter is going to come up in recklessness type of situations. You can also have a lesser included in the criminally negligent, homicide type of charges that you can ask in the guilt or innocence. When you're talking about the sudden heat of passion, though, you're talking about reducing it from a first degree felony to a second degree felony. Okay, and so the jury's got the right to make that determination whether they want to mitigate it, in other words, reduce it from the first degree murder charge or reduce it down to this second degree felony based on a sudden heat of passion.
Doesn't that just drop it down from a potential death sentence or life imprisonment to a certain amount of years in prison with bail?
Correct. Correct. Yeah. And so we're talking about a reduction in sentence here. I mean, you're also talking about a reduction in severity of what the classification of the crime is. Also, I mean, there's consequences too for whether or not probation might be available, whether or not the time on probation. There's also other aspects that go into it. I mean, it's still important because obviously, right, you're not a stone cold killer or somebody that maybe is as deserving as a harsher punishment. If you're otherwise you've been a great citizen and you just loved your spouse and just happened to be something when you lost your temper. Not to say that it's the right thing to do, but you're definitely not in the class of people that maybe, like you said, deserve to go to jail for life. Okay, and so that's when this would come in. I do want to point out when we talk about insanity, and gather we don't have a lot of time. These are really complex issues. These cases are extremely case by case. I could talk all day about each one of these, but we just don't have that much time. So, as a general broad overview, top water bait type of discussion, I think an important case that the public should be concerned about and should be activists about, and I think there needs to be a change to some degree at the legislature, is in regard to the DWI, right, intoxication type of charges that come about on a involuntary manslaughter type of issue. So you can have intoxication manslaughter, and that's where you've ingested, right, drugs or alcohol that cause you to have a wreck or some kind of collision that ends in the death of another person. Now, a lot of activists out there for the other side are saying, no, that's a great law. We need that. We need that to prevent people from drinking. I'm not aiming it at those types of situations. But what I am going to talk about is, let's say you go to your pharmacist and they fill your prescription wrong. And you think you're going to get maybe a stimulant, and your pharmacist, and it may not be the pharmacist, I mean, I'm not aiming at pharmacists here. Maybe the doctor told you he was going to give you a stimulant, there wasn't a problem with this drug, and instead he gives you a depressant that's going to put you to sleep. And so you go and take this medication, or you get the right medication, and your wife, because of, you're having trouble, maybe with some kind of maybe physical ailment, maybe your wife goes and grabs the medication for you so that you can take it, and she ends up giving you the wrong one. Mm-hmm. Or maybe you just end up taking the wrong type of medication, and you get out on the road and you start to fall asleep and you have an accident. Okay, it's a strict liability crime. And strict liability means there is no mental state. Okay, it means if you commit it, you're guilty of it. Okay, and it's like that with speeding and seatbelts. Right, you can't go to the trial and tell the judge, my speedometer was off. I didn't even know that. Right, my speedometer said that I was going 60. The speed limit was 60. Right, I've since this ticket, I've gone and got it checked out. The mechanic told me that it's off by 10 miles per hour. That's why I was going 70. I didn't know. I had no idea I was speeding. The judge is going to say, Mr. Watson, I'm sorry, but this is a strict liability crime. It doesn't really matter what you knew or what you thought. Okay, you were speeding, and that's a violation, and it really doesn't matter what your mental state was.
Can a judge, though, make the decision based on the evidence? Because of this, I can just say, we'll let this one go? Can he make that decision if he wanted to, based on other evidence?
Well, I guess he could. The state could appeal that, though, and the state would probably be correct in appealing that strict liability crime because there wasn't a basis for the judge to dismiss that. Okay, now a jury, on the other hand, we talked about the jury's right to nullification. A jury's got an absolute right. People don't know this, and if you go and sit on a jury, and if you've sat on a jury before, they tell you have to follow the law. You have to follow what the law says, and every time you you have to do exactly what the law says. Now,
these guys get so freaking emotional, it's unbelievable.
That's not true. That's not true that you absolutely have to follow what the law is. The jury's got an absolute right to nullify. They've got an absolute right to find you not guilty, right? Even if the law says you do, but they're not going to instruct you on that because, I mean, that would open Pandora's box for great defense attorneys to get that. Man,
right? The glove didn't fit. They must have quit.
I mean, that's a factual issue, right? There was an identity. It wasn't OJ because it was a different person. They were arguing an identity issue. What I'm talking about is, you're saying at trial, yeah, I did it, but what I did needed to be done. It was right. It wasn't wrong. What happened? The jury could actually say, you're right. We agree with you. And this actually happened in the days of slave laws. There was actually juries that would come in and they stonewalled a bunch of slave laws because they would find people not guilty for violating these slave laws. And there's some famous cases that I could talk about, but you have an absolute right to do that. So if a judge did it, there would be a right to appeal that. If a jury did it, that would be the end of the day, right? It would be the end of the case. But
that's why they have in the ticket, isn't it? Trial by jury, or you plead no contest, or you're guilty, right?
Yeah, nolo contendere. You can plead no contest if you want to. It's essentially the same thing as a guilty verdict. But
I don't speak that. I speak two languages, English and slang. Okay,
so in this case, though, with these intoxication offenses, right? It's not really fair, right? Because you didn't know that this happened, and you tell me, well, these cases are so far-fetched. No, these cases happen. These cases happen. I've worked on a few myself. I've worked on a handful where there was a situation where it was dealt with prescription medication, and the effects of that medication weren't known, especially weren't fully known, weren't conveyed to the person. They didn't know that they were going to have these effects, and I get that. Yeah, that doesn't. What about the victim's family? I mean, I feel for them, but we're talking about ruining somebody's life, and I realize that the other person may die or get hurt, and so their life is going to be affected, but it was not something that was criminal.
Mm-hmm.
Okay, and so those are the kinds of cases, and yeah, those are all across the board too. But there's some cases that are truly the person had no idea that this was going to happen, and yet they're getting charged for basically an involuntary manslaughter, an intoxication manslaughter case when there was absolutely no criminal responsibility on their part, because this is a strict liability crime. It doesn't matter. Okay, so I would warn people about that. Be sure what you're taking, know what you're taking, right? Because you can be charged if something happens out there on the road, regardless of what you knew.
Should we have people call in today and tell us if they're about to do something? We can tell them whether or not, that'd be a involuntary or a...
No, please don't. Please don't. But if you do have one of these scenarios, definitely I would go talk to an attorney if you've got a case pending. I wouldn't.
Do you have any in mind?
I wouldn't just plead nolo contendere. I wouldn't plead no contest to something like this. I would. There's
a good law firm would be like Copeland Dodd Krebs law firm, or attorney extraordinary.
Hey, I'm not doing that advertising, but I think Rick's probably going to say, we don't do criminal over here. But I think if maybe you're on the other side of that, you may want to go see Rick about if you got hit in your collision. But I think collisions, they say wreck, or an impact or something like that. But anyway, that's just lawyer talk. Insanity wise, so that kind of goes to the temporary insanity too. What if by ingesting some kind of substance, right, you weren't able to function, right, to develop a mental state that was required? Let's say for burglary, so to speak, there's got to be you have to break and enter. That's an intentional thing, a voluntary, but with another specific intent to commit some other kind of offense. So a burglary is, the breaking and entering of a dwelling at nighttime, right, with the intent to commit some other kind of offense. Now, burglary can nowadays, that was the old definition. Nowadays, burglary can be done during the daytime, okay? And it can be done even to a non-dwelling house, so like just a building. But there's still got to be some other kind of intent. So there's essentially two mental states there. You got to know what you're doing to break into a place, and then you've got to have another intent, right, to do something else, right? Like either rob them, commit robbery, taking it off a person, or commit theft, okay, taking some kind of item in the house, or to commit some kind of property damage. There's got to be something else, a reason why you broke in. There's got to be some other intent to commit another offense while you're in the premises of where you're breaking into, okay? And so I think you could say that, maybe you broke in, but you could not, you were so intoxicated. Let's say that you were so intoxicated you didn't know, you thought this was your house. You thought this was your house.
You go to some of these apartment complexes and all the doors look the same, so I can see that happening.
This happens. This absolutely happens. I've had a handful of these cases, okay? So these are not uncommon cases for somebody to go into the wrong location. I could talk about a couple of football college stories, buddies. I won't do that to you, but we go into the wrong house thinking it's yours. You obviously had no intent to do anything else because you thought it was your place. Does that make sense? You would be hard for you to develop that intent. So before, in the back in the day, we had this defense. We could use that intoxication to negate a specific intent. Now it's harder to use that intoxication to knock out that specific intent, but we can still attack it from, we didn't knowingly do this. We did not have an intent to do this thing.
Can you apply that to that story where I think it was the woman security guard, she went to an apartment that was upstairs thinking it was her place. You recall that story? And she ended up shooting the person she thought was invading her house, but it was actually that person's house?
Yes, I remember that story.
Does that apply to this at all?
I would think that would be either an imperfect self-defense case, or it would be like what we're saying, they simply did not develop that mental state. I was going to tell you, there was a recent case that came out in December 12th of 2018, just last month. And you're always talking about, could you shoot if somebody's breaking in the doorway? I'm of the opinion that all the scenarios that you gave, my opinion was that yeah, probably that's gonna be justified. Okay, especially if somebody's breaking in, you know they're breaking in. In this scenario, they were at a motel, just a motel where the people lived, and the guy had actually been living there. He wasn't just like a transient, resident, somebody who stayed a couple of days and left. He was living there, and the motel manager came to the doorway, and we don't know a lot about what she actually did, but she definitely was knocking on the door wanting to get in, and the guy starts firing through the door, and he fires 6 or 7 times and ends up killing the motel manager.
In my opinion, right off the bat, that's reckless. That's just totally unjustified because he wasn't coming through the door and you were shooting at something you have no idea what it was. That's my initial reaction to your story.
Okay, and it's a different. I think the environment is different. It's not like your own personal property and home. Anybody would have a right to walk back and forth on those hallways, and they could just easily have the wrong room.
Right.
Okay, and so I do think that illustrates not every time that you think you're hearing so. And the guy says he thought it was a person that had tried to kill him before coming in. That's what the defendant's argument was, that he thought it was somebody who had tried to kill him before is actually his brother, right? That he said was the person who tried to kill him before. He thought it was his brother, and so he starts shooting through the door and ended up not being his brother. Well, he didn't get a defense in that case, and so who knows? It's hard to say in any of these cases. Sometimes just one fact can make that difference about you being able to use whether or not the person knew what they were doing. But the conduct itself in what you're saying, the conduct itself is knowing. So the lady knew her conduct. The officer knew what she was doing. She knew she was pulling a gun. She knew she was shooting somebody. Okay, what she didn't know is she was mistaken in a fact about what she perceived. Okay, and so that in and of itself may not even, that she may be entitled to a self-defense claim. She may have also been entitled to a mistake of fact. Okay, there are several defenses that she may have. I don't think that it removes the voluntariness of her conduct, and that's what these insanity and temporary insanity defenses go to. They're going to the voluntariness and knowingness of what your conduct and actions are. So insanity is going to be, right, because of a severe mental disease or defect, the person does not know that their actions are wrong. Okay, and so does a severe mental disease or defect cause this person to be unaware that their actions are wrong? Okay, and so that's what we go to, and there's a lot of debate in this area, and I'll tell you, there's a famous case out there, a sleepwalking case, that a guy would sleepwalk and he ended up sleepwalking and killing somebody. Okay, and they developed a couple of tests over the years, and then there was 2 primary tests, and one was this McNaughton test. Do you know your actions are wrong based on a severe mental disease or defect? And then there's this other test. Do you have control of your actions? Mm-hmm. Okay, and so a lot of times it's the impulse test. Okay, it's the immediate impulse, sudden impulse, right, that causes you to take some kind of action where you lose control over yourself. Maybe you are aware that what you're doing is wrong. If anybody's ever seen Anatomy of a Murder, Jimmy Stewart is a lawyer. It's one of my favorite movies out there. And
Anatomy of a Murder.
Anatomy of a Murder, and it's the old case, and then there's a famous ethical scene in there where he's giving the speech, and it's you cannot, essentially, is it ethical or not to tell your clients what to say versus kind of leading them into what they need to say. And it's a famous scene in there, and the trial scenes, if you really pay attention to trial scenes, are amazing, and it really gives a view about, right, courtroom demeanor and courtroom acting, and the importance of having an advocate that's experienced at trial.
Maybe we should have a special segment with you on movie reviews. That'd be really good. I got to ask you a question, though. Let me sidebar you real quick. You said something here, and I want to do it before I forget. What if you're at your home, and you're drunk off your rear end because you're home and you can do it. And you can possess firearms in your home. And somebody decides at 1 o'clock in the morning to try to break in your house, and it happens to be the person next door going to the wrong door, and you take them out. How does that affect?
So
You didn't break the law by drinking at your house. You didn't break the law by having a gun in the house. It's 1 o'clock in the morning, somebody's breaking into your house.
in my opinion, you're going to get the presumption. Okay, and that was possibly a very controversial issue in the case I just said about the motel, but they just didn't present the case very well enough to get it there where it needed to be. But you're right. If you're in a place that you have a right to be and you're not otherwise committing an offense, and then you get one of those scenarios where somebody's trying to break into your home, then you've got the right to use self-defense, deadly force if it puts you in a situation where you thought you needed to immediately use that.
Keyword was thought, perception.
Yeah, exactly. You perceived an immediate threat that was necessary for you to react with deadly force.
That's why everybody needs to do pot out there. I keep talking about everybody. I ask everybody, do you do pot on a daily basis? And people look at me strange. Everybody must do pot constantly during the day. Perception of threat. When you're walking around, perception of threat. Is there a threat? What's the perception of it? And you got to understand your laws. You got to understand the different levels of defense. Is it reasonable, necessary force, deadly force, whatever it is, so you can apply it appropriately and be in your right state of mind if at all possible. We've got a couple of minutes here.
And so I wanted to illustrate this anatomy of a murder. I didn't even think about that before just now, but it's a great illustration because, and that's why I talk about the speech scene, because he said, well, I'm insane. And Jimmy Stewart's like, no, I mean, you knew that it was wrong to kill the guy. It was a sudden passion. This guy cheated with my wife, and I was, upset, and it was sudden passion. And Jimmy Stewart's like, nah, because it happened later, and you went and found your gun, and then you walked all the way over there to where he was. You had time for cool reflection. It's not like you walked in on him, so that doesn't work either. And he says, well, I couldn't control. I was temporarily insane. And Jimmy Stewart says, I'll be back. and we'll talk later. We'll talk more, and he's like, you think about that, and that's essentially what they pled at the trial, was that it was some sort of sudden or uncontrollable impulse that from the war. This was at the time just after the war, so he's coming back from the war and he's got these emotions, and he's on automatic flight from training, and his training with this very stressful situation caused him to go into back into war mode, thinking that he had an enemy to go attack, and so it took over his bodily control, and he went and under this control, went and killed the guy who was cheating with his wife, and jury ends up not guilty in that case. And I mean, it's a great movie, but
here's a good.
But they don't have the uncontrollable impulse in Texas. And so in order to defend on a possible ground like that, you're going to need to attack, not from an insanity plea standpoint like they did in that case, but from a standpoint of it was an unknowing situation. It was not a voluntary act. Okay, and so that becomes harder. And my point with this too is you could be medically insane, but not legally insane. And so you could get a doctor up there to say that you're incompetent or you have this insanity, this form of insanity, but yet if it was not such that you were unable to recognize right from wrong, you would still be legally in trouble. Okay, you could still be legally charged and convicted, even though medically maybe you fell under the definition of insanity. And so you don't absolutely need a doctor. It's a good thing to present, because a lot of times it's hard to preserve your error and show that it's sufficient evidence, that unless you have some kind of medical expert. But just because you have a medical expert say that you're insane doesn't necessarily mean that you're going to be legally insane.
I always bring up scenarios to try and equal what you're saying in a layman's term type of deal. Tell me if this would be applicable. You have a military veteran who's seen combat, okay? And I've seen this happen many times, where a backfire from a vehicle or a certain type of noise or explosion, something drops loud or something's rat-a-tat-tat, and you see them buck up, snap their head around, what was that? And they get in this like, okay, is there anybody else kind of mode. Would that represent what you're kind of saying as temporary, what's the word? Temporarily going back to a situation and his mind is set in an area of danger, so he does things that may not normally have been done before?
It's hard to say whether you could have a defense in that case. There's been several similar instances where the courts have not allowed a situation like PTSD to constitute a legal defense. Okay, and yeah, I mean this was actually I got denied by the armed forces. I wanted to be JAG in law school, and there's too many issues. I've broken too many. I've been crazy involved in stuff, but I wanted to go JAG because there was an issue about the PTSD, and I thought there was a lot of problems with that, and it definitely is a problem. That what you just gave, right, is not uncommon, right? That triggers some stuff, and we're not talking about just any PTSD. We're talking about the severe cases, right? And this happens, and it's cases that normally the people are being treated for already in a very intense way that may trigger one of these events. But yes, those do happen, and they happen. And I say I wanted to go JAG because they commonly happen in battlefield scenarios. In battlefield scenarios, maybe somebody flashes back to another instance of fire exchange that they had just days before, and they get into a situation and they flash back and think they're there again, and they start shooting, and it's actually in a friendly zone, and they end up doing something they get charged for, and so those things happen. Those things happen a lot.
Okay, we can go on and on. I love the conversation, but Ross, we got to cut it short. Why don't you tell everybody how they get a hold of you?
Yeah, you guys, we've getting a lot of questions. Some people I'm still working on responding to their questions. I went on vacation, so that kind of halted some things. But yeah, I've got some question and answer already. We love these because, like I said, I don't know the answer to everything, and they raise topics that we talk about on here. A lot of times we'll pick a topic to talk about here based on questions that we get. And so email me at benton@watson.legal, benton@watson.legal, and just make sure you leave your phone number so I can give you a call. Also, if you want to come see me, the primary office location here in Cameron, 105 East Main Street. That's big milk cow on the side. You can't miss it. Or call for an appointment in Houston or Brazos County. And that's 254-605-4140, 254-605-4140. And again, Rick Dodd, thank you for sponsoring the show, man. It's always a pleasure.
Dodd Krebs Law Firm. We thank you.